Welcome to Reducing Risk, a series of podcasts from Medical Protection created specifically for clinicians in Aotearoa, New Zealand. Reducing Risk looks at key medico-legal issues in our jurisdiction and provides helpful advice and guidance on how to manage those risks. MPS assist members with matters arising out of clinical care and issues with professional conduct, but not personal conduct, unless, of course, that comes before the regulator. An example of a personal conduct issue is, say, assaulting your next-door neighbour for playing country music too loud or fiddling your tax return. And whilst we don't assist with these things, we do get involved when it comes to the Medical Council. And today we have an interesting topic about how advice for clinicians who find themselves in trouble with the law. I'm Dr. Sam King, and I'm one of the medico-legal consultants with MPS, and I'm joined today by three regular panel members. Firstly, we've got Dr. Tim Cookson, who's been around MPS for a very long time. Hi, Tim.
Hi, Sam.
She's not saying you're old.
Actually, I am saying you're old.
A wee bit suspicious, but I'm prepared to give her the benefit of the doubt just on this occasion.
Calm down, you two. Dr. Lucy Gibbard, who's one of our colleagues at MPS. Hey, Lucy.
Hi, Sam.
And she's a GP. And we've got Adam Holloway, one of our partners at Watt & Carney, the panel law firm that we use. Hi, Adam.
Hi, Sam. I'm going to take a wild stab in the dark and say that I may be the youngest person in the room.
Okay.
Yeah, not so wild.
Should we emphasise this?
I think we digress.
Okay.
Let me tell you about an entirely fictional case about Dr. Sarah Smith. Now, I looked up the medical register and there is no Dr. Sarah Smith there. So please know that this is entirely made up, but it is very typical of the cases that we would see. So Sarah works as a Gen Med SMO at one of the hospitals in New Zealand. She was out late one night celebrating her daughter's 21st and drove home. She hadn't had a lot to drink and was usually very careful not to drive if she'd had more than one glass of wine. As this was close to Christmas, she was stopped at a random checkpoint and blew 460 micrograms of alcohol per litre of breath. And she wasn't permitted to drive home and was subsequently charged with driving under the influence. Whilst this story may not be common, I'd have to say it's not uncommon. Would you guys agree with that?
Definitely.
Yeah. MPS has a small but regular flow of members who face this kind of challenge, and it's not difficult to misjudge how much alcohol is in your system. So Tim, maybe I'll start with you. If Sarah was confident that there was an error, what would you recommend she do?
Well, look, I have to preface this by saying I have no practical experience in this matter. But look, what I do understand is that you do have the option to request a blood alcohol level rather than relying on the evidential breath test.
Okay, so let's just say she gets a blood alcohol and it confirms that she was over the limit, and then Sarah is charged. Whilst MPS won't assist at this point, what do you suggest she do, Adam?
You probably hear lawyers say this on TV, but it's one of those occasions where it does hold true, is there is no need to give a statement to the police or to have a discussion with them. Be polite, be humble, don't say anything, let the process unfold. Sarah Smith will be arrested and then released on police bail and given a date to appear in court. And she should either retain a lawyer for that or go and see the duty solicitor in the first instance. At the very least, that person will be able to explain what's happening in what will no doubt be quite distressing and upsetting and foreign sort of process to be going through. And so the first job a lawyer can do is actually explain what's happening, what the potential consequences are and what have you. But there is other help that a lawyer can provide, particularly for a professional in Dr. Smith's position, there is perhaps the potential to navigate through the court process in a way that might avoid an otherwise inevitable, pretty straightforward sort of outcome of losing your license, etc.
So I'm interested in that thing that they don't have to make a statement, because I think most people in that position, that automatic thing is if the police say, how much have you been drinking? When did you drink it? You answer the questions. But are you saying you're best just to say, look, I don't really want to talk to you at the moment?
Well, she's had a few drinks already,
yeah,
and maybe disinhibited, and whatever she says is going to be noted down. That may later become relevant for the medical council. So, for example, if she said she was on her way to work, then that will be highly relevant for the medical council. Or if she, says something that is transparently not true about, the number of drinks she's had, or makes up a story to try and justify her actions. This can be relevant both for sentencing, and particularly if she wants to apply for a discharge without conviction, and for the medical council. So the most straightforward thing to do is to say, okay, thank you, what happens next?
I'm not going to talk to you. I don't feel in a position to answer your questions at the moment.
Yeah, I don't want to make any statement at this time, but, tell me what happens next.
Adam, we know how lawyers do like to charge like wounded bulls. Sorry to say that, Adam, but that's very true. So DUI is a common charge. Is it important that they get an expensive lawyer, or is the duty solicitor okay? What would your recommendation be, knowing that the medical council process will be ahead of her?
I would, if resources allow, seriously consider engaging a private lawyer. And you don't have to engage a King's Counsel or the most expensive lawyer you can find, but somebody who is experienced in dealing with this kind of offence and who is able to represent you. The key reason being to at least get some advice as to whether it's worthwhile seeking to be discharged without conviction. For a first offence of having excess breath alcohol, if you're not discharged, the actual penalty you'll receive will be just a tariff. It'll be really straightforward. It'll be exactly what everyone else gets, whatever the district court probably has imposed 5 other times that morning. But you have the potential to apply to be discharged without conviction. It's worth exploring that. It will cost money to make an application like that. But if you're successful, it will be very helpful for you, both in the medical council, which we can come to talk to in a moment, but it will avoid you having a conviction on your record as well.
So often the members have already engaged their own private lawyer by the time they contact us, and they're partway or all the way through that process. If you had the opportunity to speak to their lawyer at the beginning of the process, is there anything in particular that would be helpful for the members' future process through the medical council? What would you give any advice to that lawyer that would be helpful for the member?
Yeah, look, it's not infrequent for us to be in communication, because the two processes might be happening sort of alongside each other. It's also, if you are going to apply for a discharge without conviction, what you're admitting guilt. So you're going to the court and say, yes, I plead guilty, but I'm asking you to consider, Your Honour, whether you're satisfied on the evidence, so the consequences of entering a conviction against me because I have pleaded guilty will be out of all proportion to the gravity of the seriousness of the offence. So not just that one will outweigh the other, but out of all proportion. So to reach a conclusion like that, the judge has to ask themselves, how serious is the offence? So it's a drink driving offence, but wrapped up in that are also the circumstances, perhaps, and that comes to, what did you say to the police officer who arrested you? What are the direct and indirect consequences of being convicted for that offence? So will you not be able to travel to an important series of teaching engagements overseas? Will you not be able to go and complete some essential piece of fellowship training, etc.? There can be a range of things that potentially are going to happen for you as a professional, which will be quite severe. And then, having identified how serious is the offence, what are the indirect and direct consequences of conviction, to decide whether the consequences are out of all proportion to the offending. What we get involved with sometimes is a privately engaged lawyer who's considering making an application for discharge will not necessarily be familiar with the medical counsel processes and what the consequences of conviction are. And so we can help inform them of, if this doctor is convicted, this is what the medical counsel process will look like, and the impact that it will likely have on them professionally. We've even, in cases, been engaged to draft affidavits, where essentially someone in the firm who's familiar with acting for doctors before the medical counsel will give expert evidence about what that process looks and feels like and what the likely consequences for the doctor are. And then in the criminal courts, the criminal lawyer can use that affidavit as part of what they put up to the court to say, there is enough reason here to discharge this person.
So it sounds like it's very useful if our members contact us early in the piece.
Yes is the answer. I mean, for a host of reasons. One, because it opens up that opportunity for us to assist with whatever's happening in the criminal jurisdiction. Number two, people will be anxious, I'm sure, or uncertain about what is going to happen for them in terms of the medical counsel. So being connected up with a medico-legal consultant, plus or minus a lawyer, to just help give them information and reassurance would be good. And actually just getting this in front of the council is usually not a lot of benefit and delay, and it looks good if people come forward promptly to the council and say, this has happened, I need to deal with it.
And if our members are charged or they're found DUI, I'm assuming that they can come to Watankani. And for someone, for example, would you or one of your team assist the member privately with the criminal side, and MPS through you would assist with the medical counsel side? Is there advantage in that? Or if our members wanted to do that, could they do that? So they'd only have the one lawyer to deal with it all.
What we would probably do in that situation is if their first port of call, so poor old Dr. Smith is woken up with a hangover, knowing that in a few days' time she's got a court appointment, and her first call is to MPS, and she was referred to us, we would still probably work with her to engage an appropriate barrister. And that's just because there are differences between the type of work we do in the regulatory and disciplinary jurisdictions as opposed to the criminal courts. So it would be to Dr. Smith's advantage to have an experienced but local criminal barrister who's a bit familiar with the district court judges and who knows what buttons to push or not push. We want to maximise her chance of getting a good outcome, and so we would probably not do all of that work ourselves, but rather connect Dr. Smith up with someone who we have confidence in, who we can work alongside.
Fantastic. So, Lucy, if Sarah manages to get a discharge without conviction, does she need to notify council? Or can she wait?
Well, she does. I mean, when she next fills in her APC, she's going to be asked specifically. And the APC form currently says, since you were last issued a practicing certificate, have you been subject to? Now, there are a few things there, but one of them is, have you been subject to a police investigation and or a criminal charge being laid by the police and or a guilty finding in a criminal proceeding, including convictable driving offences? And then it specifies disclosure is required even if the criminal proceeding resulted in discharge without conviction or a similar finding. For New Zealand applicants, please note your rights under the Criminal Records Act 2004 before providing details of your criminal record. So look, it is clear that in general, the Medical Council want to know if you were charged with DUI.
Absolutely. You're going to have to disclose this when your next APC rolls round, and my advice would be don't delay. There's no benefit in delaying. And in fact, there's a potential, albeit perhaps small, advantage in doing it promptly, because the council will look on that favourably, and at the end of the day, you're trying to get a good outcome out of the council. So, I would call MPs promptly, get advice, and let the council know. And often, what we're doing is we're notifying the council that a doctor's been charged before the criminal process has been resolved all the way through to a sentencing. And all the council do is say, thanks for letting us know. We'll pick this back up once we know the outcome of sentencing.
Okay.
Because the council want to know too whether or not there's been a discharge without conviction, because that will influence potentially the pathway that they take.
So, Tim, if they once the outcome is known, what will council do?
Well, they've got a number of processes, and just to pick up on what Adam was saying, if the council has a perception that the doctor is trying to minimise or avoid things, i.e. hasn't reported this until the APC fell due rather than reporting it immediately, then that puts them on the back foot immediately, because they'll be thinking, this person is a wee bit evasive, and alcohol and evasion, that's a very common association, and so they'll start off by having quite a negative viewpoint. So it's another reason for getting in early and not waiting until the APC. The Medical Council certainly takes it seriously, and not just because of the process itself having been picked up for an illegal act, but also because it's alcohol and the high association between being picked up for a drunken drive and also having a real problem with alcohol. So they'll really want to know that the potential alcohol issue has been dealt with, the health issue, and that's not going to be impacting on that doctor's ability to practice safely. But they'll go through the process within the system of the Medical Council. First of all, there's the notifications triage team who will look at the case and decide whether it's serious enough to be then progressed up to the more formal investigation of the Professional Conduct Committee. I can't think of any cases of just alcohol alone that have gone further to disciplines. So all the cases that I'm aware of have been dealt with within the Medical Council. But if anyone else is aware of a case that's gone further, obviously we can talk about that. And the ones that I've been involved with have pretty much always involved the Health Committee as well. And they go through their process to ensure that the doctor does not have an issue with alcohol that could impact on their ability to practice.
Adam, are you aware of any that have gone to tribunal?
Not for a straightforward driving offence that's not combined with other activities. So I'm aware of one case where a particular, one of many of the charge, was to do with a driving offence where the doctor had been charged criminally both with driving with excess alcohol and also failing to stop for police, and but that was in combination with a range of other conduct that was was being charged as a disciplinary offence. The relevance of the discharge in this context is that if you're not convicted, so if you're discharged without conviction, then the council has a discretion as to whether or not to send this off for a formal professional conduct committee investigation. And there are occasions where there's no aggravating features and it's pretty clear that this is not connected to any wider problem with alcohol, where the council says, okay, we accept this as what it is, it's not great, but we don't need to investigate this any further. You've been discharged without conviction, consider yourself told off. End of story, which is the best possible outcome you could ever hope for in one of these cases. If you've been convicted, so you were unsuccessful, you either didn't seek discharge or you were unsuccessful in obtaining it, because you've been convicted, the council's discretion is limited. They have to then either send you to a formal health process, which you have to consent to, or send you to a professional conduct committee. So once you've got a conviction, then you know you're either going to be investigated from a health perspective or investigated from a disciplinary perspective, conduct perspective, or potentially both. What they would tend to do is write to you and say, okay, well, you've been convicted. There are these two pathways available. Do you consent to the health pathway? We want to know that in advance. And also tell us, the circumstances of this, what led you to be in this situation, and then we'll decide which pathway to send you down, knowing that health is an option because you've consented to it. If health is an option, you'll be sent off to the health committee and engage with them. There may be some testing that occurs to detect whether there's evidence of a sort of chronic overuse of alcohol, and depending on the results from that will guide what happens down the health pathway. If you're sent to a professional conduct committee, they'll want to know the circumstances of the offending, etc., and whether there are any aggravating features. But as Tim said, I'm not aware of any just plain, straightforward excess alcohol cases that have then gone on to a disciplinary charge.
That's good to hear. I'm aware of a case where the member or the doctor, nothing further was done. They weren't sent to investigation by the notifications triage team. And the factors that led to that decision by the NTT was that the doctor had pleaded guilty, was discharged without conviction, obviously took it very seriously, the doctor. There were no aggravating factors. He took responsibility for his actions, entered a guilty plea at the earliest opportunity. And I think he'd also done some work with with an alcohol rehab centre, not that there was any health issue, but had taken it that seriously. And I think that those factors really helped to end it at the NTT stage, which I thought was actually very good.
Yeah, and often you will, I think, find if people have been successful in getting discharged, then they would have been well advised by their criminal lawyer to take actions like that, because they all help. And then we can springboard off that and say, or make our own advice about things that might be helpful to do to present a case to council to try and stop it at the preliminary stage before it goes on to either a health or a conduct investigation.
I know that often members, when something happens, whether it be a complaint or something like this, you can feel a little defensive and come across that way. But I think that, well, in this particular case, it was really helpful that the doctor was very open, there was obvious remorse, understood the seriousness, and demonstrated that he'd taken it seriously by going through some kind of treatment and education, etc. And I think that that's a good thing. I think that is the approach that we need to take.
Absolutely. I mean, it always helps with the medical council if they can see that you genuinely are reflective and accepting of the issue. I think that's that's always going to be a good thing.
Yeah, I think most of us, I think if you watch too much American TV, we tend to think it's better to not say anything and not admit to anything. But actually, I think...
Well, we've learnt that you're not to say anything on the night.
Yes.
We've learnt that you're not to say anything on the night. But when it comes later on to taking responsibility, I think that's what they want to see, isn't it?
But that's interesting, but not saying anything on the night, because I think that actually would be a real challenge for
I imagine
most
it would be a
people
real challenge, yeah.
Because we're conditioned to comply, basically, particularly in the medical profession.
To
not
be
saying
fair,
anything.
yeah, in the context of excess breath alcohol, you're probably not going to
Say anything too bad.
sink yourself too deep by answering straightforward questions
It was
about
only
how
a bottle
many.
of whiskey.
but you just never know, you know. I've had a case where, I mean, it will be resolved, but it's now a thing we need to resolve, where the police said, where are you heading? And the doctor said to hospital. And so the assumption is that they are going to work under the influence of alcohol. What they were really doing was going in on their day off to pick up some teaching resources because they were teaching registrars in their spare time the following day. A very laudable and not clinically risky thing to do after a glass of wine. But, things start getting written down and more questions get asked. So, I don't think you need to be aggressive or impolite with the police, but it's tricky because I imagine most doctors will never get arrested, and even those that do, it'll be a one-off event. So it's hardly something that you get used to. But volunteering statements to the police before you've had a chance to take legal advice is something lawyers normally advise against.
Good advice there, Adam. Lucy, we have a number of members who have health problems related to alcohol or other substances. Can you just explain what additional support that MPS will provide for our members in that situation?
Yeah, well, obviously having a DUI charge is a risk for having an underlying problem with alcohol. And often the medical council, that is actually one of their significant concerns, is does this DUI actually suggest that this doctor has an underlying disorder that may affect their ability to practice. And that's generally where the health committee comes in. The health committee is there to make sure that the patient population is safe, that doctors who have a health condition that affects their ability to practice are at least monitored. And in that situation, MPS will assist our members in their dealings with the health committee. As is previously mentioned, in those situations, the health committee will often want reassurance as to the doctor's ability to practice. They will often want reports either from an addiction specialist or the patient's own GP. They will often want testing, liver function tests, CDT testing, all sorts of different testing. And if they have ongoing concerns, they may want there to be monitoring. And there are processes in place where some doctors are required to have breath alcohol readings done before each shift or before each day they work, or even just twice a day, every day. So with all those responses to the Medical Council, MPS will help our members with that. And
I'm assuming that a number of our members who have these sorts of issues will also have employment issues.
Yeah, and ASMS will probably, if they're members of ASMS, so if they're hospital specialists, they would often help if there's an employment side to that. With GPs, often there isn't that support from a union, and in general, MPS doesn't necessarily help with employment matters. But often we're helping with the health committee. So from that point of view, we are being helpful, but we're not necessarily going to directly help with employment.
Right. I think there's been a lot of cases where I've worked alongside ASMS officers for our members and just working in tandem, which I think is really great wraparound service actually for our members. So turning to more serious offending, we've had a number of cases, usually male doctors who've been perhaps falsely accused of sexual assault during a consultation. And thankfully it's not common, but I'd have to say that it's not terribly uncommon as well. So Tim, starting with you, because you've worked as a GP for a very long time, how did you protect yourself from false accusations?
Well, it's interesting. This is an area where things changed dramatically during the course of my practicing time anyway. So in the early days, the thoughts of having a chaperone, it just was never considered, basically, in general practice. But certainly by the time I ceased being a GP, yes, every female patient, for example, who was going to have any sort of intimate examination, a chaperone would be offered. Now, most of the women that I was seeing at that stage, I delivered their children, and they would look at me and they'd say, "Tim, you've seen it all before. I don't need anyone there." But I wouldn't do an examination on a woman that I'd never met before without having a chaperone present. One thing that was on my mind by the time I ceased, but I hadn't actually taken any active steps, was I'd always just made the assumption with examining a male for an intimate examination that would be absolutely fine. I don't think that's the case anymore. And so, should all men, if the male doctor examining a male patient, should that patient be offered a chaperone for an intimate examination? That's certainly, I think, the way things are headed. Historically, we never saw women doctors being accused of inappropriate sexual activity. That is also starting to change. So I think women who might have assumed there's no need for me to have a chaperone now need to consider that. So yeah, it's been a very steady shift towards taking increasing precautions for protection.
It's very tricky, isn't it, particularly for the male doctors, but I think it's scary to think that some female clinicians are at risk as well. Because you're right, it's not something that we've had to consider at all. So Lucy, as we've said earlier, we don't assist with matters of personal conduct, but does MPS ever assist with criminal matters arising out of consultations?
Yeah, so generally we can assist in some of these situations. We have discretion, so we're allowed to assist if we think it's appropriate, and we have to be consistent with that. But if there's a case where the conduct happened in the clinical setting, or the accused conduct, alleged conduct occurred in a clinical setting, and there was no malicious intent, that actually the examination was an appropriate examination, and we believe that actually there hasn't been misconduct, we definitely do assist in those cases. Sometimes the allegations are very historic. It's something that the doctor is alleged to have done 20 years ago. And in those situations, look, you don't know if the patient's misremembered. The doctor probably can't even remember the consultation. And in those situations, we generally assist. If there is clear evidence of criminal behaviour, which I agree is very rare, but if it's actually criminal behaviour and there is very little doubt, then actually we wouldn't generally assist with criminal matters. However, obviously we do assist if that matter went to the medical council. So we will assist in those situations with the medical council, but we don't generally assist with criminal matters.
Even if there is some uncertainty about whether or not MPS would assist in terms of funding the criminal defence as opposed to funding lawyers for the engagement with the medical council, MPS is still the right number to call.
Yeah, absolutely.
Because you will get some good immediate advice from the medico-legal consultant you're speaking to, who used to taking these calls in high-stakes situations, and be able to connect you up with a criminal lawyer who they've got confidence in and who has some experience in dealing with these allegations that interface with clinical practice. So regardless of who's going to end up paying the bills of your criminal lawyer, rather than not knowing who to turn to or who to pick, or being faced with the sort of impossible task of trying to figure out what the right lawyer is to call, just call MPS and they will help you on the spot, and they'll be able to send you to the right kind of lawyer who you need in that moment.
And particularly in the case of alleged inappropriate sexual activity, this is something that the medical council takes incredibly seriously. And so getting early advice from lawyers around that is particularly important. And we've certainly had cases where it's clear that the medical council takes the view that we've had the allegation, we don't have evidence to disprove it at the moment, and therefore we have to take actions that will protect the public, and they can become quite draconian.
Absolutely. And often you feel in some of those cases where it is a he said, she said situation, that actually the consequences for the doctor, when there is actually very, we don't know what happened, but the consequences for the doctor feel like punishment right from the beginning, where they have restrictions on their practice and all sorts of things. So I think Adam's 100% right that call MPS, because we will do our absolute best to help.
And things can drag on as well. And I remember one terrible case where the allegation was, it was bizarre, but it was an allegation, and the police dragged their heels, didn't do anything about it, and until the police had finished their investigation, the medical council was going to continue to impose the restrictions, which were quite significant on this poor doctor. And in the end, the lawyer involved had to threaten the police with the police complaints authority to get the matter dealt with properly, so that it could then be dealt with by the medical council, because they wouldn't do anything until the police had finished. So, yeah.
Very tricky, isn't it, for our members in these sorts of situations? I'm thinking about a number of cases that I've been involved in where it just seems that the GP has conducted a perfectly normal intimate examination and nothing unusual in it. It might be historic, it might be just part of a normal gynae exam. The patient has consented to having an intimate examination, and then all of a sudden there are allegations of inappropriate touching. What happens, Adam, when it comes down to he said, she said? How did the police approach that?
I'll start with a very significant caveat, which is that this is not the area I practice in. So the comments I'll offer are not necessarily first-hand or expert in the true sense. But if someone comes to the police and makes a serious allegation that they believe 15 years ago they had a consult that involved, in essence, a sexual assault, I would expect the police to take that seriously, and they would take a statement from that person. They'll be looking for corroborating evidence. They'll be wondering whether or not concerns about the examination were reported to anyone else ahead of walking into the police station. Most powerfully, were there any contemporaneous discussions with friends or family about what happened? That would all be relevant evidence for the police to be seeking. They may try and have a voluntary interview with the doctor concerned and approach them and say, look, this allegation's been made. We'd like to take a statement from you. Please call a lawyer. It won't even necessarily be that the advice you receive is not to participate in by giving a voluntary statement, but you deserve to have spoken to someone who's looking out for your interests before you make that decision. So they'll be seeking information from the doctor concerned. They'll be trying to get hold of the relevant records. So they bring together what information exists, and then there will be a process around whether or not this meets the guidelines for bringing a prosecution, which can be a difficult decision. And that could involve, for example, the police seeking expert view from another GP, if that's the context, about the nature of that exam, whether it was clinically indicated, the method by which it was conducted, etc. And they have to go through the process of in the internal police and prosecution process that they must work through before deciding, are we going to charge this or not? Do we think that we have a realistic prospect of proving this? And if they do, then they'll arrest the doctor concerned. And if you haven't got a lawyer already on speed dial at that stage, then again call MPS and get a lawyer to look after you, both for the immediate trauma of being arrested and dealing with bail, which historic offence almost certainly will be granted bail, but you need to work through achieving that and what the bail conditions are going to be. You want to immediately jump onto potentially having your name suppressed, the process of probably entering no plea to the charge to buy a bit of time so that you can get proper disclosure of what information the police have in their possession, and you can be advised about what the appropriate strategy is for dealing with this charge. It may be that ultimately you're heading to a trial, or it could be that the lawyer who's helping you, once they've seen the police disclosure, can have some robust discussions with the prosecution about whether this is really appropriate. I guess your absolute best case scenario is that your lawyer can persuade the police that they've made an error and have the charges go away. But all of that's pretty high stakes stuff, so you don't want to be walking that road alone.
So if the police drop the matter and the doctor's not arrested, how does medical counsel respond to that? Would they normally let the matter go, or will this go to PCC?
I think it depends. Every case will be different. I've had lots of cases where police have been briefly involved in something, quickly came to the view that it's not a matter for them, and the medical counsel have accepted that and accepted the doctor's explanation, and it hasn't required any further investigation. But there are also occasions where, for whatever reason, the police decide not to bring a charge, but there is a real concern over conduct that is worthy of investigation. Remembering, of course, that what the police are interested in is whether a criminal offence, which have specific offences and specific elements to those offences, has an offence been committed, and can we prove that an offence has been committed beyond reasonable doubt, which is a very high standard, whereas what the medical counsel was concerned about is, has this practitioner been negligent or committed malpractice? In other words, are they guilty of professional misconduct, which is a more amorphous and possibly quite different set of questions that are being asked as opposed to criminal offences. Is the circumstances in which this examination occurred, despite there not being a crime, actually still professional misconduct? So what the counsel is interested in may be different, the questions they're asking may be different, and the standard is different. The counsel only needs to prove their case on the balance of probabilities. So you certainly can escape the criminal jurisdiction but remain in trouble with the medical counsel and ultimately the disciplinary tribunal.
But the medical counsel would only know in that situation, because there hasn't been a charge, so you wouldn't have to necessarily put that on your APC. So they'd only know about it if the patient had actually also complained to the medical counsel. Is that right?
Yeah, and there could be a range of different ways that the medical counsel become aware of it.
Yeah.
The patient could also have complained to the council. The police may have approached the council for information about the doctor. There's lots of ways it could come to the council's attention.
Very serious topic that we're talking about, but I think it's been very interesting. And I think whilst not many members go through any of these sorts of processes, I think for those who unfortunately do find themselves in this situation, I think it's really good to have some idea about what to do ahead of time. So thank you for that, everyone. Adam, would you mind just giving us some take-home messages?
Yeah, I guess my it sounds like I'm banging on the same drum, and it's often my take-home message. But do call MPS if you're involved with a criminal process, because it is high stakes, and even if it might seem run-of-the-mill, like I've had too much to drink and driven my car, it can have quite serious professional consequences for you. And MPS is incredibly well set up to provide you with really quick and effective advice, or connect you up to the right people who will be able to help you. So get help. It is quite common, I find, for some people who have been arrested to have a real deep embarrassment and a sense of shame, and wanting to keep it quiet or a secret, and that delays them from seeking help, which is a real shame because it can actually just make things harder in the long run. So get help, and if the police turn up out of the blue and knock on your door and say, look, we just want to know whether you're interested in giving a statement to us, because a patient from long ago has suggested that something went wrong during a consult, just say, look, it's not a no, but I'd like to talk to a lawyer first, please.
Great. Yep. Good advice. Thank you for that. So thank you for listening to this podcast. I hope it's been helpful, and I hope that you don't actually ever find yourself in that situation. We look forward to catching up with you in our next podcast. If you like the Medical Protection podcast, please subscribe and leave a review. If you would like a podcast on a specific topic, please email nzpodcasts@medicalprotection.org. Thank you, Adam, Tim, and Lucy.
Thanks, Sam.
Thank you.